As well as making laws, government also needs to enforce them. The importance of this cannot be understated. A government can make all the laws it likes. If these laws are not enforced, the law will be held in contempt by the electorate, law and order will break down, and anarchy will ensue. Enforcing the law has two main components. Firstly, the law needs to be policed, so that criminals can be brought to trial. Secondly, a justice system is required, so that suspects can be tried, and offenders punished. In modern societies, we often forget just how fragile law and order is, and take it for granted. This is a mistake. History shows how easy it is for law and order to break down, and how dismal the consequences are. Without even looking at the past, in many cities in the world, there are currently areas where the police are hesitant to tread, and assault and robbery are commonplace. We see that, in these areas, crime often goes unreported. Victims of crime consider that reporting a crime is pointless, as it will not lead to any effective action against the criminals by the police. Indeed, reporting a crime may not only be considered pointless, but positively dangerous. In the absence of effective policing, criminals are likely to commit acts of violence, or take other retributive actions, against those reporting a crime. To maintain law and order, it is important that people have visibility of, and confidence in, the police. This can be achieved by having police officers patrolling the streets, interacting with people. This has several advantages, including the following. The mere fact of having policemen about has a deterrent effect on criminals, reducing the crime rate. Studies have shown that having cardboard cutouts of policemen in shopping centers can reduce the incidence of shoplifting. One might reasonably consider that having real policemen walking about would be an even greater deterrent. Police on the street are particularly effective in quickly dealing with minor crimes and antisocial behavior at the point that they are being committed. Reducing the rates of these crimes can have a disproportionate impact in making people feel safer and less stressed, and build confidence in the ability of the police to enforce the law. It has been demonstrated that a zero-tolerance policy to policing, where even minor offences are taken seriously, followed up, and the perpetrators brought to justice, reduces the incidence of more serious crime. When any crime is committed, police officers already in the area can reach the scene more quickly, maybe early enough to prevent or interrupt the crime, deal with the aftermath, and quickly start any investigation. This also builds confidence that the police are active and vigilant. If people believe that the police are doing an effective job, then they are more likely to report things to them. If police are present and interacting with people on a daily basis, then it is easier for people to report things to the police. If you are used to encountering the police as you go about your business, and having them wish you good day, they will seem less threatening and more approachable. If you see or learn something that you think the police might be interested in, it is easier to mention it to the officer on patrol, who you happen to meet on your way to the shops, than to find the time to make a call, or send an email, or whatever. So, police obtain more information, and can more effectively enforce the law, which in turn deters would-be criminals from committing crimes. To put against these benefits, is the cost of training and paying extra police to work in this way. However, given the key importance of maintaining law and order, it would seem reasonable for spending on police to have a higher priority than many other areas of government spending. In the UK, in 2018-19, total HMRC tax receipts were £623.4 billion. Total spending on the police was £12.3 billion, of which £8.6 billion was paid for by central government. These figures indicate that paying for more effective policing by reassigning government spending, rather than by raising taxes, is likely to be realistic and achievable. I have previously described the paradox of government, that to protect people from violence, the government must use violence. Now, the logic of a democracy requires that all voters have equal legal rights, so if the government has powers to use violence against any voter, it will have the power to use violence against me. I accept this, it is a price I am prepared to pay for the protection that law and order provides. But, I want to make sure that power is not used arbitrarily against me. In particular, if I am accused of a crime, I want to have a fair chance to rebut that accusation, and, if successful, avoid any punishment. That opportunity to defend myself will not be fully meaningful if I have already been subject to punishment. Now, it may be that, in practical terms, I will have to be subject to some physical force over the period before I can put my case. For example, I may be detained pending trial. But, in general terms, I want to be presumed innocent until I am tried, and, as far as possible, treated as a law-abiding voter over that period. Turning now to my trial, how do I want that to work? You might say that it would simplify matters, and reduce costs, if trial and sentencing was done by the police. After all, the police will have investigated the crime in order to identify me as the suspect, and will thus have all the required information readily to hand. But am I going to get a fair trial from the police? There are reasons why I may not. Defending myself may involve criticizing the case that the police have built against me, pointing out what they have missed, how they have misinterpreted the evidence, or flaws in their reasoning. So, if the police find me not guilty, they would be admitting they were wrong. They may not wish to do this. Further, if the police are assessed on the number of crimes they solve, then finding me guilty makes their performance look better. I therefore want to be handed over to a justice system that is independent of the police, to make it more likely that I will get a fair trial. Further, that justice system should enable me, as a private individual, to bring a case against the police, if I feel that the police are acting in breach of the law, or bring a case against another person, if I feel that a crime has been committed but the police are not willing to prosecute the perpetrator. If I am on trial, I want my innocence or guilt to be decided by a varied group of people, rather than a single individual, or a group of people all with similar beliefs and outlook. The reason for this is that people are all different, with their own subjective attitudes and beliefs. This can lead to situations of mutual incomprehension. Addressing myself to a varied group of people makes it more likely that one or more of them will appreciate my view of events, and so understand my motivations and actions. This increases the likelihood that my arguments will be given due weight by the group, and so get reflected in their verdict. You may have noted that I am using the word varied, rather than the word diverse, which might seem a more natural word. Unfortunately, the word diverse has been hijacked by the metropolitan liberal elite, who seem to use it purely to refer to differences in ethnicity, gender, sexuality, and so on. A committee can self-congratulate itself on its diversity on such grounds, even while its members are trapped in comfortable woolly groupthink, and would throw up their hands in horror if it was suggested that someone who might challenge their views should be added to their number. I am not particularly interested in differences in ethnicity, gender, sexuality, and the like, as in my experience such differences are most often largely irrelevant to whatever is being discussed. What I mean by a varied group is one which has members with different opinions, beliefs, and perspectives. If the group deciding on my innocence or guilt consists only of professional judges, then it will be less varied than a group of randomly selected voters. I therefore want to be tried by a jury. This also aligns with the desirability of having simple laws, with clear objectives, setting out the key principles by which guilt can be judged in any particular case, rather than detailed regulations, designed to capture every possible situation in advance. Such principle-based legislation avoids the need for detailed legal argumentation, allowing jurors to use their judgment in reaching a common-sense verdict, based on the objectives of the legislation and the unique circumstances of the case. Once a criminal has been found guilty of a crime, the next step is to sentence them to an appropriate punishment. The first question you may ask is, why do we punish criminals at all? There are three main reasons. The first is to deter people from committing criminal acts. Potential criminals are less likely to commit crimes if they think that they will be punished for them. A criminal who has been punished may think twice before committing another crime. To be an effective deterrent, a punishment needs to be unpleasant. The second reason is to protect the public. If criminals are locked up or executed, they will not be in a position to commit any further crimes. The third reason is revenge. If you are robbed, say, you will have a natural desire to see the robber suffer, as they have made you suffer. If you think that the robber's punishment is inadequate, you will feel that justice has not been done. You may even consider taking the law into your own hands, and that is the path to anarchy. So, while it may feel uncomfortable to say so, revenge is a key reason for punishing criminals. Let's assume for a moment that you have been found guilty of a crime. You may say that you should not be punished, as you have been forced to crime by your circumstances, or are otherwise not responsible for your own actions. So, for example, you don't choose to persistently commit acts of petty theft. You are a kleptomaniac with a psychological disease that deserves our sympathy. Well, on one level, I don't care why you stole my silver teaspoons. I just want you to stop stealing my stuff. Regardless of whether you think you are metaphysically free, if you know you will be punished for it, you will be less likely to steal. Regardless of whether you have free will, you can't steal my stuff if you are in prison. And regardless of whether you have free will, I may still have an emotional need for revenge. So, all the reasons for punishing you still stand. As for you being a victim of your circumstances, well, it is true that environment, particularly the environment people were brought up in, seems to have a significant impact on how they behave. This may help me to understand why you act as you do. But it does not absolve you of responsibility for the choices that you make. Different people brought up in identical circumstances can, and do, turn out very differently, because of different decisions that they have made, or not made. Similar arguments apply to claims that you have no control over your actions because they are genetically predetermined. And if you really do have no control over your actions, then you should most definitely not have the vote. As a non-voter, it might well be that more restrictive laws and different penalties apply to you. But laws will still apply. You might say that you should not be punished, because doing so doesn't respect your human rights. This sounds very fine. However, it is based on woolly thinking regarding what your rights are, and how they arise. You only have rights because you live in a society where law and order are enforced. In the absence of law and order, you would not have those rights, and you cannot consistently demand the protection of those rights, while breaking the laws that deliver them to you. To put this more bluntly, if you are a criminal, you have chosen to forego such rights. You may argue that, although you have been tried and found guilty, the verdict is incorrect and you are innocent, and so you should not be punished. Now, punishing the innocent is undesirable, and so it is important that there are checks and balances within the justice system to allow people a fair trial. But, on the basis that you have had a fair trial, once the judicial process has run its course, and a guilty verdict has been passed, society has to assume that it is correct, and that you are guilty. Otherwise, no trial would ever reach a conclusion. If there are concerns that too many innocent people are being found guilty, the remedy is to change the way in which people are tried, not to desist from punishing criminals. Given that criminals are going to be punished, how might that be done? There are various punishments that have been used in practice, each of which may be appropriate in slightly different circumstances. I will consider some of these in turn. This is not intended as an exhaustive list. One way people can be punished is that they can be made to pay a fine. Nowadays, that fine usually goes to the state. But it doesn't have to. For example, under Anglo-Saxon law, if you killed someone, you had to pay a defined sum of money, wergild, to their family. Particularly where the financial impact of a criminal action can be quantified, it might be considered reasonable to require the criminal to pay a sum to the victims, sufficient to repair the financial damage that they have suffered. However, this is unlikely to be considered a sufficient punishment. Merely having to give back what you have taken if you get caught does not act as much of a deterrent, and may well not be regarded by the victim as adequately punishing the crime. This could be addressed by applying additional punishments in combination, or increasing the amount of the fine. Another type of punishment is corporal punishment. For example, criminals might be sentenced to be whipped. This used to be very common. It has some advantages. It is cost-effective. The costs involved in whipping someone, and then letting them go, are significantly less than those of imprisoning them over an extended period. It can be used against people who do not have the assets to pay a fine. It enables the punishment to be delivered and over and done with quickly, which for minor offences means that everyone can move on, and get on with their lives. You might object to corporal punishment because it involves the overt use of physical violence. But the law is always backed up by violence. If you are sentenced to prison, you will be taken to prison and kept there against your will, and, if you resist, the state will use physical force against you. So, I don't accept that argument. If you think that corporal punishment can be effective, you might argue for more inventive forms of it, such as cutting a thief's hand off, or using branding irons to permanently mark people who have committed crimes. This would certainly be a significant deterrent to those who have not yet committed a crime. However, a mutilated criminal will be marked on sight as a criminal for the rest of their days. Knowing you are permanently marked as a criminal in this way might well alienate you from, and turn you against, society. It might also make it difficult for you to find a non-criminal occupation, and be accepted in it. In practice then, mutilation may act to embed people into criminal ways, rather than deter them from committing crimes in future. I think it is best avoided. While fines and corporal punishment both have a deterrent effect, and may satisfy the victim's need for revenge, they do not prevent the criminal from committing further crimes. This is a great advantage of imprisonment. It both punishes the criminal, and protects the public. It may also be that while in prison, a criminal can learn new skills and reflect on the error of their ways, reducing the likelihood that they return to a life of crime once they are released. However, the proportion of released prisoners who subsequently reoffend indicates that this does not seem to happen routinely in practice. A disadvantage of imprisoning people is that it is expensive. The state has to feed prisoners, and pay people to guard them. This cost can be mitigated if prisoners are made to work in ways that create value, and I see no reason not to do this. Another form of punishment is capital punishment. Modern societies are increasingly turning away from this. But committing some crimes, for example those involving premeditated sadistic cruelty, precludes ever releasing you back into society. People will be frightened of you, with good reason. No one will trust you, want to live on the same street as you, or stand next to you in the supermarket checkout queue. If it is proposed to release you back into society, there will be an outcry. If you are never going to be released, is it really worse to kill you than to lock you up forever? Economically, killing you is certainly cheaper. Further consider, for example, that when those who have sexually assaulted and murdered children are imprisoned, they need to be protected from their fellow prisoners, and if they are released they need to be given false identities, to protect them from the vigilantes who think the death penalty should have been imposed, and will seek to remedy this by imposing it themselves. This demonstrates that at least a section of the public feel that the death penalty is appropriate if you commit these extreme crimes. Some argue against the death penalty on the grounds of its finality. Others would argue for it in these cases on the same grounds: by committing these crimes you have chosen to act in a way that forever precludes you from being part of society. By doing so you have irrevocably set yourself against the rest of us, and permanently forfeited your rights to protection by the law. Why should society keep you alive? Whatever you feel about these arguments, it is clear from the preceding discussion that a wide range of punishments can potentially be used when someone is convicted of a crime. How can society decide which punishment best fits the crime? Currently, in the UK, if the jury returns a verdict of guilty, it is the judge who passes sentence. This seems strange to me. After all, in reaching their verdict, the jury will have considered and discussed the case in depth. In doing this, in my experience, a jury will also have formed a view on how serious the offence was, and the degree of punishment that would be appropriate. In my view, if a jury finds a person guilty, it should also be asked to propose an appropriate sentence, and I would allow juries very wide discretion in doing this. You may argue that this could lead to a lottery, where very similar offences could receive very different sentences. I argue that this doesn't matter, each case will be different, and so comparing cases, even cases that are superficially similar, is very difficult. However, to give juries a starting point, the judge could provide examples of a range of sentences that have been previously pronounced on people convicted of that offence. This does mean that a jury will need to be informed of an accused's past criminal record, and punishments previously received. After all, if you are a repeat offender, then whatever punishments have been handed out to you in the past have clearly not had the desired deterrent effect. A jury needs to know this, so it can consider if alternative punishments should be used. There may be reluctance to do this, on the grounds that if the jury know that you have a criminal record, this may prejudice the jury against you. The flip side of this is that the fact that you have a string of previous convictions for committing similar crimes is, at least in my view, a relevant consideration in determining your guilt and culpability on this particular occasion. However, if this is a concern, the information regarding your past offences could be passed to the jury once it has decided on its verdict, but prior to sentencing, rather than at the outset of the trial.